all run back to your offices and hop on your respective calendars or caucuses or whatever each party calls it. I would like to welcome Representative O'Hobson to the committee. It's the first time we've seen him this year in person, so it's good to see him live and in real life. So welcome, sir. Committee, today we're going to start working 2416. Again, I hope to be here till about 9:55. We'll see where we're at and likely come back after floor debate today to keep working. But things are fluid, so we'll see how that plays out. Is there any interest by anyone in having Natalie remind us what 2416 is? If so, let me know. If not, I assume you know what the bill is. Let me switch my screen so I can see everybody waving at me. Okay, then we're going to just jump right in. I have one technical amendment. Natalie, if you would send that one out. This is, you'll recall, on the bottom of, well, let's let it get sent out. Bottom of page 2, line 41, there was a reference to 48.924 F2, and it should be 48.925 F2.
Mr. Chairman, I would also note there's a second technical amendment on page 4. There is a reference to reviewing proposed executive orders as provided in section 2. And now, because we have that review happening both in section 1 and in section 2, I thought it would be best to just reference reviewing those orders as provided in KEMA.
Sounds good to me. I will make that motion to amend. Is there a second? Representative Hoheisel, any discussion on this amendment? Hopefully they all go this easy. I will close. All in favor say aye. All opposed say no. Motion carries. I'm going to work through a list that I've made as I've heard from people that have amendments. Next, Representative Jennings.
Thank you, Mr. Chairman. Much like yours, pretty straightforward and simple amendment that will be distributed. This amendment would simply add in the 9/11 dispatch center personnel to the definition of emergency responders so that they would be in that cohort as others. Strikes me that those people are pretty critical to operations. If you call there and there's nobody there, nobody comes. So
we'll get that popped up on the screen. Second by Representative Owens. Representative Carmichael, do you have a question or comment?
I have discussion at the appropriate time.
Let's do that while it's coming out.
Okay. I have not seen the amendment, nor has it popped up on my screen. Well, maybe it just popped up on my screen over here. But there has been an ongoing discussion as to whether or not dispatch personnel should be classified as first responders. And while I know at first glance, folks would say, gosh, aren't they already first responders? Why aren't they first responders? Why aren't they treated the same way? And while it is absolutely true that dispatchers are prone to acquire PTSD as a result of telephonic contact that they have had with people in distress. And while it is true that there are a very few dispatchers that are deployed to the field to staff emergency services communications trailers, this is a much bigger issue than one that we ought to be considering just based on, yeah, it sounds like a good idea. There are collateral consequences in designating dispatchers as first responders. There are also cohorts of other individuals who might be equally or even more entitled to that designation. And so I realize that this is important to the professionals who engage in dispatching activities, but it is not wise to put this amendment on this bill without due consideration. And I therefore must reluctantly oppose the amendment without testimony and support. Thank you.
Further discussion? Not seeing any. Representative Jennings?
I close, move the amendment.
For the motion, all in favor say aye. All opposed say no.
No,
No.
The ayes appear to have it. The ayes do have it. Representative Jennings, are you done with your amendments? You're done. Representative Schreiber?
Thank you, Mr. Chairman. If Natalie can pull up the amendment on extending the initial duration of the initial disaster emergency from 15 days to 30 days. It appeared in 2 or 3 locations in the entire bill. And the reason for that is there was testimony in the interim committee that identified that 15 days was a rather brief time for some emergencies. Others, it would be appropriate, but this would allow the emergency management response and so forth to go forward without going through an extension process if needed. So that's the amendment.
Is that a motion?
Yes, I'm
There-
sorry.
Is there a second?
Yeah.
Representative Long? I would just echo, not really taking a position on this amendment, but we did hear that. I think I specifically asked some of the conferees in the KEMA meeting, how long did a typical disaster last? And we heard 21 to 30 days. Most of them are resolved. So just to confirm that we did hear that. Let's see. So the amendment's on the screen. I don't have it in my email yet though. So let's give. Is there any discussion while we're waiting on the amendment to pop up? Representative Jennings?
It looks like it just arrived. This
Yeah.
just makes it 30 instead of 15 days. Is it that simple?
Correct.
Okay. Everybody had a chance to read that?
no, Mr. Chairman, the amendment just now popped up on my screen.
I'll give you a little bit longer, no worries. Just checking while you're reading this. Representative Samsel, can you hear me? I got a text indicating you might not be able to hear us. Can everyone else online hear me? Yes?
Yes.
You text him and tell him maybe he should turn up his computer. Has everyone had a chance to review the amendment?
I'm sorry, Mr. Chairman, so far as I can tell, it still has not arrived on my computer. I have one at 9:08. It's a technical amendment. It says this was Patton's amendment. I have one at 9:07, which says 2416 balloon. Ah, there it is. They came out in the wrong order. 30 days PDF. I
There we
assume
go.
that's what
Yep.
we're on.
Yep, I think that's the correct one.
Moment, please. Mr. Chairman, I do have a question either for the maker of the amendment or the reviser as you deem appropriate.
Okay, ask away and we'll see who wants to answer.
At page 4, lines 29 through 35. Oh, that's actually not a part of the balloon. I apologize. Trying to read quickly.
You're fine, take your time.
Mr. Chairman, I appreciate your indulgence. This appears to be a good amendment to me. Thank you.
Any further discussion? Not seeing any. Representative Schreiber, you may close.
I close.
Heard the motion. All in favor, say aye.
Aye.
All opposed, say no. Ayes appear to have it. Ayes do have it. Representative Schreiber, any additional amendments?
Not at this time. Thank you.
Representative Burris.
Thank you, Mr. Chairman. If I could have Natalie distribute the amendment entitled 2416 combined. So may I explain?
Yes, you may.
Thank you, Mr. Chairman. So as far as I understand it, Section 1 of this bill provides for a new process that it was brought to my attention that there's a possibility it may not necessarily be subject to the KSA 48-925 enhanced protections for example, elections. And this amendment would move the enhanced protections for elections to under KSA 48-923. So if my understanding is correct, that would make sure those enhanced protections for elections would apply in every context of KEMA, including Section 1. And the language that's being moved, I would note, is obviously this bill's language, which was taken from HB 2016, which of course was passed during the 2020 special session. And my amendment does two other things, but I think I might pause there and allow Natalie to supplement if necessary.
I guess just maybe a question for you or Natalie. This is existing language that you're moving from somewhere else and simply copying and pasting it in there?
I'm basically this amendment would move it from Section 5, the current Section 5, to a new section and place it under 48-923, which, as I understand it, in the context of KEMA, 48-923 is basically a provision of KEMA which makes clear that certain things can or cannot be done, or KEMA applies to certain things and not to others. And then I guess I might as well just go on, if that's okay, Mr. Chairman.
Yes.
So the other things are, I believe, well, basically, two further changes. It would add two more items to 48-923. One, as you, and I'm hoping everyone has got the amendment by now. It would say that the governor cannot limit the movement or gathering of individuals connected to the worship of God or the exercise of religion, or to regulate the conduct of religious services. Obviously, as I'm sure most people remember, the governor, through Executive Order 20-18, included in her mass gatherings prohibition churches. specifically churches or other religious services or activities. And this was not long before Easter. And I think based on a press conference she gave, it on the language she used and the things she said, it was really focused on making sure that churches could not basically gather to commemorate Good Friday or celebrate Easter. And I just think that in light of Section 7 of the Bill of Rights of our state's Constitution, that's not appropriate. And I can discuss that further, obviously. And then the last amendment, or the third item in this amendment would basically say that the governor shall not have the power or authority to temporarily or permanently take any action that gives preferential treatment for elective abortion. And I remember the governor refusing to, in any way, touch the abortion industry. And I just think, I heard early on in the pandemic that, we're all in this together. Well, I just think that the abortion industry should suffer along with everybody else if the governor is going to shut down all or parts of a particular industry. So that's basically my amendment, Mr. Chairman.
Are you moving your amendment?
Yes, sir, I would like to move it.
Is there a second? Representative Owens? Discussion committee or further questions? Representative Heiberger.
Thank you, Mr. Chair. I would oppose the amendment. Certainly the right to worship in this country is one of our highest values. It is enshrined in our Constitution, but gatherings of individuals during a time of pandemic are dangerous to public health, regardless what their purpose is. We saw a number of religious events that became super spreader events early in this this crisis. And I really think it's a mistake to tie the governor's hands on this issue. And just second, regarding to the abortion provision, I think if you want people to listen to what you say about abortion, don't use the phrase abortion industry. I think it's completely misleading and distorting, and I find it kind of offensive, with all due respect. So I will oppose the amendment.
Representative Carmichael.
Thank you, Mr. Chair. I echo the remarks of my learned colleague from Douglas County. This amendment is taking way too big a bite with far too little consideration. It touches on, according to the maker, 3 areas of the law. I have to tell you that it would be impossible for me to read and properly consider this complex amendment in the time available. We should not be making hasty decisions based upon knee-jerk reactions that have a very broad application. If we need to amend the chairman's hard work on this bill, then we ought to take it up one piece at a time, and we ought to take it up in a fashion where we see the amendments and then can go back and truly look and see what the collateral consequences of an amendment is. The chairman and others spent hours and hours and weekends drafting this bill. And while I may not support a number of the things that are in this bill, undertaking to undo the chairman's work on on a hurried basis and turn his work into something else is bad policy making. And for that reason, if not for other reasons, I must oppose this amendment. Thank you, Mr. Chair.
Representative Samsel.
Thank you, Mr. Chairman. I do want to echo the positive comments about all the work that's been put into this particular bill and the amendments. And I will keep this brief in the interest of time, but my concerns actually go to, not as the representative from Lincoln pointed out last time, not to keep George Washington trending, but for the people listening back home, his comments to me are just so spot on here, because I understand these changes to be permanent. So not just for the current situation, whether we classify that as an emergency or not, but also once we get through this one, and we will be in a better position for it, but the next emergency that comes to Kansas, and we're using these same statutes that are on the books, and these things are hard to change once they've normally through their process gone through both houses and signed by the governor, or if the governor vetoes, then the override. But point being, they're difficult to change. But just a couple lines that I want to share with the folks back home. But George Washington said, resist with care the spirit of innovation upon its principles. Although there's certainly good motives, he says that the experience is the surest standard by which to test the real tendency of the existing constitution of a country. And so he goes to wrap this up here. He says, although there may be an instrument of good, it is the customary weapon by which free governments are destroyed. So I'm concerned as we start making changes to what's already a difficult situation, an emergency or something very close to it, that we're altering the balance of power, not just between the executive branch and the legislative branch, but also those within the legislative branch. The good people of Kansas put 125 representatives and 40 senators to represent them in this building for a reason. So this would be a much easier bill for me to support if these changes were temporary, perhaps if they had an expiration date. But to make these permanent, for all of the reasons on both sides of the issues that have been discussed today, I'm going to have difficulty getting behind this, but I realize that we can make additional changes, but to make these permanent for however long they may be is difficult for me. So with that, I will quit trending George Washington's other fine points in his very long speech here, but I appreciate the chair's work and everybody else's consideration today.
Representative Hoheisel.
Thank you, Mr. Chair. I have one question for the maker of the amendment. Are these changes in the Senate version of the KEMA bill currently that you're aware of?
Thank you, Mr. Chairman. I think the only one would be the third item related to elective abortion.
Okay, so the religious gatherings and stuff, that's not in the Senate version currently?
I do not believe so.
Okay. I'm going to agree with my representative friend from Wichita on this. I believe there's good things in here, and I admire the fact that you're bringing these today. But this, an amendment of this size that changes the scope of this bill, I need more time to study the implications of some of these changes. I think there's definitely some I can get behind, but I kind of need a little more time. So I would rather this be, I guess, discussed maybe on the House floor or maybe in conference committee. But I need a little more time to kind of go through and study all the implications that we're doing with this. So I will oppose this amendment today, but I want to keep working on these issues with you. So thank you.
Representative Owens.
Thank you, Mr. Chairman. I rise in support of this amendment, although I haven't previously read it. I don't have any great quotes by George or Ben or any of the other good folks that my good representative from across the way has so learnedly studied. However, when I read this, just in kind of plain language, it says nothing in KEMA shall be construed to allow you to interfere with the course of labor dispute, interfere with the dissemination of news, effect other than, during a declared emergency jurisdiction, limit or modify the authority of the governor. However, we do make a very clear point that we do not support some very specific principled parts that our Constitution protects. And I think that, in my opinion, movement, right to express your religious freedoms, intolerance of abortion, I think putting those things in statute are incredibly important, because to me personally, and to many others that I know, these are fundamental protections that should be codified in statute as we have seen other things in our Constitution codified in statute, to further reiterate their importance. So with that, I do stand in support of the amendment. Thank you, Mr. Chairman.
Representative Heiberger?
I would just point out that the Kansas Constitution currently protects the right to abortion.
Representative Jennings?
Thanks, Mr. Chairman. A question for the carrier of this amendment. On the last item, number 3, I read that to actually apply in essentially 2 scenarios. One would be we're not going to treat an elective abortion any differently than we would any other elective medical procedure. You could stop there. I think there's 2 parts to this. So I think it's acknowledging that an elective abortion is a medical procedure, and that if other elective medical procedures are curtailed by executive order, then these would be considered one of those. Is that kind of a fair way to characterize it?
Rereading it, probably.
Okay, and then part 2 would be, let me call this the McDonald's part of it. Although McDonald's may not be a great one, let's call it the neighborhood gym. This would be, in essence, to say in part 2 that with respect to abortion providers, which I think means, their procedures that they perform, that they couldn't be treated differently than any other business or commercial activity. So I guess that means, I don't know what that means. Some businesses were affected and closed, other businesses were not closed. So which cohort of businesses does this apply to? Because it generically says business, and I think we've had examples of 2 different types of action around business in the state during at least the most recent pandemic. So help me understand what that means.
I'm not sure I can offer that much assistance. The intent is to basically make it so that the abortion industry, and yes, I will use that term, is not given preferential treatment over any other industry. At the very least, that was at the very least my intent in that regard.
Representative Carmichael?
Thank you, Mr. Chairman. I'd like to address the portion of the bill that deals with restrictions on movement. And as best I can tell, this specific provision, except for line 41 at page 10, the strike there, it looks to me like in the balloon, at least, we're talking about movement in association with some religious activities of one kind or another. Religion is protected at the highest level in our country. The free practice of religion is. It's contained in the First Amendment to the United States Constitution. It stands right up there with freedom of speech, freedom of the press, freedom of expression, freedom to practice one's religion free from governmental interference. And as we saw during the initial stages of this pandemic, the courts are not at all hesitant to protect the free exercise of religious rights. And in fact, the standard to be imposed or to be utilized in reviewing whether or not governmental interference with free practice of religion is the strict scrutiny test, the test that we heard vilified particularly a year ago and again earlier this year in connection with the Supreme Court's decision in Hodes versus Nassar, or in essence, the abortion case that established the right of bodily autonomy in Kansas. So we don't need to go around sticking in specific protections for religious activity here, there, and everywhere in the Emergency Preparedness Act. We know that the courts are not hesitant to protect the free exercise of religious rights, even in a pandemic. And that when it is necessary to make those types of restrictions, the strict scrutiny test applies, means it has to be very narrowly construed or crafted so as to interfere to the least possible extent with the free exercise of religion. We know that there has to be no other reasonable way to accomplish the legitimate governmental purpose, in this case, the purpose of saving lives in the midst of a pandemic or emergency. And we know that the court will utilize the strict scrutiny test. And so it's really not necessary for us to start grafting on additional statutory rights, which might have unforeseen consequences in circumstances, quite frankly, that as we sit here today, we cannot truly foresee. I can think of an example. Let's assume that we have a terrible tornado in a county west of Pratt, and that the tornado in essence levels the town, and that there, in my example, are natural gas leaks, propane leaks, that there's been breaches of the chlorine containments at the water plant, that contagions have escaped from the feed yard. The governor says there is a strict quarantine on this area. There will be no movement into or out of, because it is dangerous for people to be there. We don't know what the problems are, but we know that there are things there that can kill people, and there will be no movement out because we know that folks may have been exposed to contagions that we absolutely cannot allow to escape from the area of this natural disaster. We can't have, in a circumstance like that, a number of ellipses and commas and buts and maybes and ors in that. We can't have a situation where my free exercise of my religious right would allow me to carry the contaminant from, in my example, the city west of Pratt, back home to Wichita, so that I can attend a religious convention in my hometown. And we have a number of stopgaps. I would argue too many stopgaps and too many reviews and too many questioning of what a governor's authority is, not only statutory authority, but also a governor's constitutional authority. And while I know it's very appealing to say I protected the free exercise of religion when I voted on an amendment in a committee in the House Judiciary, and I did my best to stop the scourge of abortion when I voted on an amendment in the House Judiciary Committee, and we could go on, but the point of the matter is that this amendment is unnecessary because religion is protected. And we shouldn't be making this type of wholesale revision without supporting testimony and evidence to explain not only why it's necessary, but moreover, what the collateral consequences and unintended consequences of our acts are. So if we have to pass this bill, we need to keep it clean, keep it where it is now. Don't start this morning or maybe even this afternoon on the fly, trying to rewrite the bill without the benefit of due and proper consideration. Thank you, Mr. Chairman.
Representative Wheeler.
Thank you, Mr. Chair. This KEMA bill is very important for the protection and safety of the people of the state of Kansas in the event of an emergency. And to add this language in by amendment to this bill is very concerning to me. What I don't see in the bill, and I don't see in the amendment, is a savings clause. That if in the event any part or portion of this bill is found to be unconstitutional, the entire bill would be unconstitutional without the savings clause, leaving the remainder of the bill in effect. I also think that this is pushing the borders of violative of the single subject rule. So for those reasons, I will oppose this amendment.
Representative Humphreys.
Thank you, Mr. Chairman. I have been listening online. I didn't just, I just want that to be clear. I didn't just jump in with random thoughts. So I've heard the discussion. I think the title, for one thing, of the amendment is interesting because it's combining all these different things. And I think that is what's happening here, albeit some things are being added. As far as when I look at the section 4, it's gonna, number 2 talks about the news, which we know we have freedom of the press. We know that's very important, as is freedom of religion. And to carve it out and protect it as we did news, I think makes a lot of sense. And if these rights hadn't been grieved, then I don't think we would bring this up. But we've seen it, and we know the Supreme Court, even on Friday night, issued an opinion for some church, for a county in California, saying, no, you will not limit your religious services, our U.S. Supreme Court, by the way. So I think I like having that in there. And I think the piece about abortion, it has to do with the fact that if we're calling abortion a medical procedure, it was treated differently than other medical procedures. And that's why this amendment says it will not give preferential treatment. And it's going to be treated as other medical procedures because we saw what happened last spring and last summer. So for those reasons, because I don't think it's unreasonable, I don't think it's this huge thing. I think it's combining different things. I will be voting in favor of the amendment. Thank you.
Representative Samsel.
Thank you, Mr. Chair. I'm also going to vote in favor of this amendment. I don't know when else the representative was supposed to bring this given our limited time. And not to beat a dead horse here, but this is important to me because last March, we were shut down, especially in rural parts of Kansas. And not only were we shut down, but our voices were silenced. So we were told what to do, and we weren't allowed to do anything about it or have a voice at the table. For 2 months of our lives that we'll never get back, that went on. And I believe everyone had good intentions while they did it. But this will hopefully be my last quote, but this is why it means so much to me and the people in my district when we talk about liberty and freedom. This was real life. The habits of thinking in a free country should inspire caution in those entrusted with its administration. Well, now we're taking that power from the legislature and giving that to the LCC and the governor. And I have not seen caution shown by those two groups in not wanting to take on this power. I don't want the power as a state representative, but I've not heard that from any of the proponents of this bill who are going to be getting the power. And that gets into confining themselves within their respective constitutional spheres, avoiding in the exercise of the powers of one department to encroach upon the other. This is the key to me. The spirit of encroachment tends to consolidate the powers of all the departments in one. That's what I see happening with the LCC and the governor's office. And then you create, whatever the form of government, a real despotism. The goal, as George Washington said, is to divide and distribute the powers into different depositaries of that power. So when this bill comes to a final vote, the best I can do probably today is to pass it out without recommendation. I don't think I can pass it out favorably, but I will support the amendment for that reason because at minimum, I think it deserves continued discussion by the full body. Thank you, Mr. Chair.
Representative Ralph.
Thank you, Mr. Chair. I'll chime in just at this point because I'd be left out if I didn't chime in at this stage. But I did want to say that I have agreed with the comments from the representative from Lycan and the representative from Wichita on the other side of the room. at this point in time. We will never remove all of the ambiguities from any particular legislative action, but as I look at these particular phrases that are being proposed in this amendment, it's pretty easy, pretty quickly to identify a significant number of ambiguities and concerns as to how that language may actually apply in the real world. And at the very least, I think this takes or is in need of additional wordsmithing, if you will, to ensure that we are in fact doing the things that we intend to do, not necessarily disagreeing with the intention underlying any of this amendment, but in order to ensure, and as we've seen in the past from the old emergency language, if we miss out on the language at this point in time, 5 years down the road or 10 years down the road or 20 years down the road, in the next time this comes up, we may be confronted again with a situation of we didn't take the time to actually wordsmith and say exactly what we intended to say. And that's my biggest concern at this point in time. So I won't be supporting this amendment. Thank you, Mr. Chair.
Representative Owens.
Thank you, Mr. Chairman. You know, it's always interesting when one approach is good for a certain group of people and then it's utilized, but then when somebody else tries to utilize it and the shoe's on the other foot, the approach doesn't seem to fit. The fact is we amend bills. That's why we're in committee. That's part of this process. Sometimes they're big, sometimes they're small. Sometimes we even gut and go entire bills on the House floor with zero time to research things. So that argument doesn't resonate with me. From the standpoint of where I believe that the representative is coming from, is that abortion was deemed essential when 90% of other businesses were not. You took a procedure that many of us stand opposed to, and some don't. It's perfectly fine. It's how it is. But that was deemed essential by a governor when other things were not. When there are other governors around the nation that did not believe that that was essential. So regardless of who is governor, I think that this plants our stake in the sand that we do not believe that this is essential. So for them to be prioritized over other businesses or companies just baffles me. And I might just add to the vice chairman's comments, you know, there may be some ambiguity in language, but we are trying to rush something that this House, the House version of this, did not want to rush originally. We wanted to have until June to work the bugs out, to get the language right, to go through the process longer, June, or I would argue even January. So the fact that we are put on a very narrowed time frame, there is going to be some ambiguity in language. And so when those things happen, we've got to work them out. We can't work them out sitting right here because it's very important, as I understand, that we get this passed out. So we have one of two options when it comes to ambiguity of language. That is, we either pause, we get the language fixed, we come back and we debate this amendment, or we put it in there, we put our stake in the ground and say, no, we don't believe abortion is essential. And we'll have the opportunity to work out the language either in the floor or most certainly in conference, because our version of this bill is going to be substantially different than what the Senate passes out. So there will be plenty of opportunity to work out the ambiguity in language. I think from a House position, putting our stake in the sand and saying we do not believe abortion is an essential service gives us a great point when we go into conference. And with that, I won't raise any more comments. Thank you.
Representative Heiberger.
Thank you, Representative Owens, for the lead-in. I will point out that an abortion is different than most other elective procedures like plastic surgery or even a hip replacement in that it is time sensitive. And I see this as just another attempt to use the power of the government to force women to have children that they don't want to have.
Further discussion on the amendment? Do not see any online or in person. Representative Bursch, you may close.
Mr. Chairman, members of the committee, thank you for your time. Thank you for the discussion. I don't want to belabor things too long. Mr. Chairman, I do want to say I definitely respect and appreciate the work you have done, you know, in terms of this bill. I intended no disrespect to you or anybody else, you know, through these amendments. I would just say that with respect to elections, I want to make sure neither neither of them, no political party is able to use an exigency to alter or modify, suspend election laws, and I think the people of Kansas definitely are in support of that. With respect to the second item, limiting the movement or gathering of individuals connected to the worship of God, I recognize that I recognize the strict scrutiny test as applied to religious freedom, or I recognize that the U.S. Supreme Court in First Amendment contexts applies strict scrutiny. My observation, though, is that Section 7 of the Bill of Rights of our Kansas Constitution seems to provide enhanced or more robust rights or protect religious freedom to a greater extent. The first independent clause says the right to worship God according to the dictates of conscience shall never be infringed. The third independent clause says, nor shall any control of or interference with the rights of conscience be permitted. We're talking about, or at least I'm sorry, I'm talking about the movement or gathering of individuals in connection with the worship of God. And the governor, I think, made it clear that she wanted to make sure that Christians, I do think she singled out, I think it's very easy to infer from her comments during her press conference and her executive order 20-18 that she was singling out Christians and the observance of Good Friday and Easter. And I simply think that the people of Kansas, through Section 7 of the Bill of Rights, wanted greater protection for their religious freedom. And again, my amendment refers to gathering, just the mere gathering of individuals, which, since I believe that the governor singled out Christians, just as an example, Christians have been gathering for millennia to worship Jesus Christ. And then finally, with respect to the third item on abortion, I would just note that Section 1 of our state constitution's Bill of Rights says that all men are possessed of equal and inalienable natural rights, among which are life, liberty, and the pursuit of happiness. I find it interesting that life is the first of the expressly enumerated natural rights. And yet somehow our Supreme Court finds an extremely broad, and I'm bringing this up because it was brought up, it makes no sense for our Supreme Court to find in Section 1 an extremely broad right to abortion, including by dismemberment. It's baffling. And I just want to make clear that through the third item, I am not personally trying to say that abortion is a mere medical procedure, because it is not. I do condemn abortion, and it should, but at the very least, when our governor or any governor wants to shut people's businesses down and seriously damage our state's economy, at the very least, I think it's appropriate to make sure that the abortion industry, I will use that term, suffers just along with everybody else. So, Mr. Chairman, members of the committee, thank you for your time, and I do respectfully move my amendment.
For the motion, all in favor say aye.
Aye.
All opposed say no.
No. No.
Noes appear to have it. Division's been called. All in favor, raise your hand. All opposed, raise your hand. Appears to be 5-11. Motion fails.
Oh, yay.
You're unmuted, Annie.
Sorry.
It's okay, catching you early. Those wanting their,
Mr. Chairman, on this important vote, I would like my negative vote recorded in the minutes, please.
we got that. The affirmative votes wanting to be recorded are Owens, Burris, Humphreys, Neely. And negative votes, we've got Carmichael, Heiberger, O'Hobson. Very good. Okay. It appears to be 9:50 if all the clocks are matching and we're following these clocks. I assume we have additional amendments.
Mr. Chairman, I do, but given the time, I don't know if it now is appropriate.
So, I mean, here's where we're at. I want to stop in about 4 minutes so everyone has time to get to wherever they're calendaring or caucusing. What do you guys call it? Agendaing. Is that a verb? So everybody has time to get back where they need to be. So let's stop for now. We will come back at the end of floor debate today, unless I find out we're taking a long break at lunch or something, which I don't think we are. So I will make an announcement of when that's going to be, and we will pick back up and stay until we get finished, hopefully. So thank you all for your work. We'll see you all in a little while.